So it's 4:05. We want to be mindful of all of your very valuable time. So we're going to get started. So today is the fourth in our four-part training series on evictions. Today's training really is going to focus on the nuts and bolts of getting people where they need to go quickly to get the resources, get access to the resources that are available. So many of you may have heard that the state has presented a program or rolled out a program known broadly as an eviction diversion initiative. So while many parts of this program are kind of still getting off the ground, we are going to give you kind of a brief overview of the different pieces involved in that program. So the first piece of that puzzle is 211, the phone system.
Get started?
Can you hear me, Steph? Can everyone else hear me? I think Stephanie may have frozen.
I can't hear you.
I think everybody else can. So I'm going to keep going because I think you know this information. So while Stephanie gets her audio reconnected. So the first piece of the eviction diversion initiative is the 211 system. So it is a phone system where people can call in and get referrals to the various resources that are available. And we're going to touch on what each of those resources are. Right now, 211 is still getting up and rolling. They have operators available, but you should advise clients, if you are referring them to call 211, that they may need to wait for a call back, that they may not be able to get through right away. But I know 211 is ramping up their capacity. They are working on that. And hopefully very soon that really will be a much smoother system for people to call in and get information. But in the meantime, we are providing you this information. So basically, we're going to give you today all of the information that 211 will have, so that you have it to, refer people on your own without them separately needing to call 211. The second piece of the eviction diversion initiative is money. So as we learned last week through the DHCD training, a large amount of funds have been set aside for rental assistance. And that money is flowing through the HCECs, the Consumer Education Centers. And we're going to show you today how to locate the appropriate center for a given client, because it is geographic based. Within the HCECs, as they are meeting out rental assistance funds, my understanding from conversations that I've had at this point is they will be doing some kind of trying to work things out between landlords and tenants, but it's largely going to be limited to those scenarios where there's enough money. So in other words, some people are eligible for $4,000, some people are eligible up to $10,000. If the pot of money that somebody is eligible for works, meaning not too much money is owed and the tenancy is sustainable going forward, or there's enough money within the pot that's available to support somebody going forward, then the HCECs, the RAFT agencies, will work things out with the landlord and hopefully divert the case from eviction, ideally in court if it's not already in court. There will, though, be some number of cases, and frankly, we're thinking it may be a lot, that the pot of money available may not be enough. So the tenant who may be eligible for the $10,000 because their eviction is COVID related, they lost a job due to COVID, but they owe $12,000. Those cases where basically the math doesn't work, there's not enough money to completely cure whatever rent is owed, will be referred to community mediation groups who will try to work out some sort of an agreement between the landlord and the tenant outside of court. And in that agreement, there's going to have to be either some waiver of rent by the landlord or perhaps a payment plan, depending on the individual situation. Additionally, and kind of on a separate track, those cases that are already in court, the tenants still will be able to access rental assistance, and those who are eligible will receive rental assistance, but the cases will largely be mediated by the housing specialist department for those cases that are in the housing court. So that's kind of the money piece with also the mediation piece that has been built in. In addition to that, there's been some money funneled into the tenancy preservation program to allow them to take on a larger number of cases. And so they will also be available for cases that are appropriate to provide some additional assistance to help preserve tenancies. And that's really going to be situations where the answer isn't just money, right? So the answer may be money plus the need for some sort of additional support services, money with referrals to help with sustainability, things of that nature. And then the last piece of the eviction diversion initiative was an influx in funding to legal services. And so we have been given funds and are in the process of hiring a number of additional attorneys and paralegals to help provide more representation to tenants who are facing eviction in court. And so for our purposes, the best way to get access to those services is to refer people to our intake line. So I'm going to share with you now on the screen. Let me share my screen and just, if everybody can give me a thumbs up if they can see this, if it's clear enough. If not, I can zoom in. Okay, so we've developed kind of a quick flow chart to help you kind of quickly identify what needs to happen depending on where somebody is in the case process. So if a tenant has received a notice to quit, the first thing that we're asking you all to do is to, and sorry, let me back up. The idea is that this plan kind of works within the broader eviction diversion initiative, and that as that program gets built out, we may reach out to you with some additional information about how to get tenants to access the resources that have been made available under that program. But for right now, this is the plan that we believe will allow you to quickly refer tenants to the various resources that have been made available under the eviction diversion initiative in the quickest way and in the most effective way. So we first ask, for you to confirm with the tenant if they've received a notice to quit. So if they have, the first thing we would ask you to do is to assure them that they do not need to move out. They have the right to fight the eviction in court. Like we talked about in the first training series, and if you missed that, it is available. You can watch the recording, you can review the PowerPoint, but the notice to quit really is the first step. And while it does tell a tenant that they are required to vacate, they are not required to vacate until a court order tells them that they have to. So just please assure any tenant who has received a notice to quit that they do not have to leave if they do not have somewhere to go. So then we would ask that you try and determine with the tenant what the reason given in the notice to quit is. So we went over in part 1 of our training series the different types of eviction. A tenant can be evicted for non-payment, for no fault, or for cause. And so if the eviction is for non-payment or for no fault, no reason at all, we would ask that you refer the tenant to the CDC declaration as well as to rental assistance resources. So we covered this in the first training, but I'm just going to quickly once again show you the CDC declaration form. And you'll recall that basically the form just requires tenants to be able to affirmatively state that they qualify based on their income, that they have been unable to pay the full rent due to a loss of income or extraordinary medical expenses, that they're doing their best to make partial payments, that if evicted, they would become homeless, be forced to double up, or be forced to enter a shelter, and that they understand that they still owe the money. So we would ask that any tenant facing eviction where there is rent owed, whether that eviction is filed for non-payment or for no fault, we're advising tenants to complete the declaration form and give it to their landlord. So that would be step one. In addition to this form, there is a self-guided interview similar to the MAID system that we reviewed last time, for tenants to also complete this form online. They can then just email it to their landlord or print it out and give it to their landlord. And I will send that link around after the training as well. So the next step would be to refer the tenant to rental assistance. So how do you know where to send them? So you can go to the HCEC website, the Housing Consumer Education Center's website, and quickly identify using this or this search field where you pick the town, and it will tell you which agency covers that city or town. And each of the agencies at this point is participating in kind of a uniform application system. This was another change under the Eviction Diversion Initiative. And so most or all of these agencies now have an online portal where tenants can apply for rental assistance. There is additionally a paper application if needed in certain circumstances that they can use. Go back. So those would be the first steps. Get them the CDC declaration and refer to rental assistance. And I just want to highlight that these are live links. So when we send this form to you, if you have it electronically, stored on your computer, you can click on these links and they will take you to the exact pages that I just showed you, to easily guide you to where you need to go to get the information to get the person to the right place. And then the final step is we would ask you to refer to legal aid. So as we said, we are in the process of hiring a number of additional attorneys and paralegals and intake staff to help us face what we are now already seeing as a large surge in evictions. And so at each stage, we ask that you refer the people to legal services. We are, under the Eviction Diversion Initiative, we are hoping to have points of contact through the courts, through the rental assistance agencies, and through other community partners to help funnel tenants to legal assistance and make sure they're getting that legal assistance. But as these systems get set up, we are still really going to rely heavily on you all to make those referrals, to give tenants that you're seeing the information so they can get where they need to go. So and Stephanie, I can't really do the chat while I'm screen sharing, so if you can take care.
I got it, no worries.
Thank you. And so how do you know where to send somebody for legal aid? So many of you work with us, the Justice Center of Southeast Mass in Brockton regularly. So many of you have our intake information, but perhaps you are working with somebody from a different area, or you have, your organization has offices in other areas. So the Legal Resource Finder, which was also linked on that quick action plan that we have, can help you determine which legal aid office covers the service area of the tenant in question. So they're currently actually in the process of revamping this site to make it a little bit easier to use. So it will change in the next couple of weeks. But for right now, you can simply type in the city or town. You don't need to fill out any of the additional information unless you want to, and search that way. And it will bring up any legal aid programs that cover that city or town. And so you can easily refer tenants that way. So let's say that, where did my, hold on, sorry. So let's say that the eviction was for cause. So the notice to quit indicates that there was some lease violation or some behavior by the tenant. In that case, we're asking, rather than referring to the CDC declaration and rental assistance, just refer them directly to us, to legal aid, and also give them the masslegalhelp.org information so that they can, on their own review materials directed to tenants, explaining the eviction process and giving them just some basic information as they go through the process. Again, our hope here is that we can help every single tenant, but the reality is that that's likely not going to happen, at least not initially, and that it may take time for us to get back to people, for people to get through the system, for us to get back to people. And so we'd like to arm you all, and by proxy, arm all of these tenants on the steps that they can be taking in the meantime. So as they may have to wait at each of these points for rental assistance, for legal aid, to contact TPP, while they're waiting, there are things that they can be doing, and we want to arm them to do those things so that when they do get through to us, they're in a better position than if they're simply left waiting. So after the notice to quit is the summons and complaint. So again, this is the document that is going to indicate that a case has been filed in court. If they have received the summons and complaint, we're asking that you refer them to the GBLS MAID system that we reviewed last time, or alternatively provide them the form, answer, and discovery documents that we emailed to you afterwards and we highlighted on the masslegalhelp.org website. And then additionally, again, refer to legal aid using the legal resource finder if you're not sure which legal aid office is the appropriate referral point. If they have not received a summons and complaint, you can simply tell them that that's the next step, that they likely will receive a summons, and that once they do, or even before, they should call legal aid. So I know I'm sounding like a broken record here, but please bear with me. So let's say they've not yet received a notice to quit, or they don't believe they have. Then you can ask them if they've received a summons, because we do know from projects that we've done in the past where we've surveyed tenants who have cases in court that many state that they didn't receive the notice. It's sometimes mailed or left on doors, and it can be, moved or sent to the wrong address, or things can happen. So it's possible that somebody has received a summons without receiving a notice. So if they have received a summons, you're going to go the same route of refer them to MAID to complete an answer in discovery, refer them to legal aid. And if, if there is rent owed, again, refer them to rental assistance resources and provide the CDC declaration. If they've not received the summons, simple again, if they owe rent, give them the CDC declaration, refer them to rental assistance and to legal aid. And then I would say if they don't owe any rent and they're, just concerned about their housing situation generally, a referral to masslegalhelp.org is always helpful. So in addition to this flow chart, the second page contains a quick glossary just explaining what's a notice to quit, what's a summons, what's the CDC moratorium, and also just kind of 5 quick key things. So they don't have to vacate after the expiration of the notice to quit. If they owe rent, they should give their landlord the CDC declaration. They should be referred to rental assistance as soon as possible. They should file an answer in discovery and a jury demand. And then finally, which Stephanie's going to talk about in more detail shortly, the last point in this notice is that we know that tenants are going to have, and landlords, frankly, are going to have difficulty accessing the court now that it is virtual and remote. Particularly those landlords and tenants where English is not their first language, or they have a disability, or simply lack the technology or the technological knowledge to access the court. And so for those people, a call to the court or to the court's kind of assistance line are the best ways to address those problems. And Stephanie, again, is going to go into more detail on that. And then finally, at the bottom here, we have the direct link to each of these trainings to give you, again, that broader background for you if you need a refresher, or for others in your offices or the community at large, to get kind of more of a grounding in evictions generally, and the resources that we've highlighted here. So the last thing that I'm going to highlight for you before Stephanie takes over is the mass courts system. So after reviewing that flow chart that we just went over, many of you may be asking, okay, but what if the tenant doesn't know? And that frequently happens. Tenants often don't know the status of their case. They don't know where they are in the process. Maybe they didn't receive the notice to quit. They didn't receive the summons. They're not sure if there's a court case filed against them. So when that happens, they can, of course, call the court. But another way that they can check is by using the mass court system. So this is online access to the trial court's file system. The access is not complete. So unless you are an attorney, if you're searching cases in this system, you will not be able to see criminal matters. You will not be able to see certain family law matters, and you will not be able to see any documents. What you will be able to see is the court's docket system. So you'll be able to see whether a case was filed. You'll be able to see whether any hearings have taken place, whether the judge has issued any orders. And so this can be a really great resource for any tenant who just isn't sure. They think maybe there's a case that's been filed. Their landlord said that they filed a case, but they haven't gotten any paperwork. So you can go to masscourts.org. You have to confirm that you are, in fact, not a robot. My 18-month-old would have trouble with that because he currently believes that he is a robot, or at least likes to tell us that he is. So the first step is to pick the court. Generally speaking, for our purposes, you're going to be selecting housing court. Cases, summary process cases, eviction cases can also be filed in district court, but the majority are filed in housing court. So if you have a tenant who believes that there's been a case filed against them, the first place I would suggest checking is the housing court. You next have to choose the division. So the housing court is divided, excuse me, into 6 divisions. The divisions for the Southeast are clearly the Southeast Housing Court, which covers the Cape and Islands, Bristol County, and some of Plymouth County. Metro South Housing Court covers really northern and western Plymouth County, as well as Norfolk County. So for our purposes, we're going to look at Metro South. So there are a couple of different ways that you can search. You can search by the name of either the tenant or the landlord. You can search by case type, or you can search by case number. Typically, if the tenant isn't sure if they have a case, they're not going to have the case number. And so the easiest way to search is using the name of either the tenant or the landlord. So for our purposes, we're going to search by landlord. And we're just going to search for the Brockton Housing Authority. So you simply type in the company that you're looking for and you search. This is going to pull up a large number of searches just because they obviously are a landlord, they file a number of cases. If you're searching under a tenant's name, it's going to be much fewer. And what it will do is it'll pull up a listing of cases. It'll show you the case number, the date it was filed, as well as the type of action that was filed. So we'll just look at this one. And so just a quick overview of case numbers. The case number really is a code. So the first 2 numbers are going to tell you the year that the case has been filed. So if you have somebody who's concerned that they've had a case filed and 5 or 6 cases come up when their name is listed, one quick way to try and sort through is just look at the first two numbers of the case. If it's a 20 case or a 19 case, then it is possible that that's a pending case. That's something that they need to worry about. If it's, an 18, a 17, a 16, it's unlikely, though not impossible, unlikely that that case is still going on. In housing court, the SP indicates that it's an eviction case, and then the last numbers are the actual case number, the specific to that case. I'm not going to get into the other numbers, but essentially those identified the specific court. So H2 is the Metro South Housing Court, and each of the different divisions has a different number. But for your purposes, that isn't as important, because if you're using this system, you're already looking within the division. And so what you're going to see when you open the case is basically a reflection of the court's internal docket system. So, and when by docket, I basically mean kind of the calendar of events, what has happened.
Could you zoom in on your screen just a little bit, Laura, if you don't mind? Thank you.
Is that better?
Perfect. Thank you so much.
So with each entry, you'll be able to see the date, and the easiest two quick ways to check to see what's going on are first, here, the status date, and the next event. So that's going to tell you, is there something coming up that they need to worry about? Additionally, if you scroll down here, this tells you, okay, when's their next hearing date? It'll be the latest date listed on this list. And then finally, if you scroll all the way to the bottom, case disposition will tell you if the case has ended, how it ended. Additionally, you can just look at the last entry. So if you're seeing something that says judgment, then that suggests that the case is over. If you're just seeing one entry that says file date, then that indicates that the case was just recently filed. And so this can be a way, in addition to calling the clerk's office to find out what is happening, this can be a way for tenants to determine what's going on in their case. So if you're working a little bit more in depth with somebody, they're calling you saying, I think I have an eviction, I don't know what's going on. Using mass courts can be a great way to just quickly determine, okay, is there something or is there not? I would just 2 points of caution is one, keep in mind from our first training that there is a lag because the summons and complaint is served first and then the case is entered. So it's possible that someone could come to you, have a summons and complaint and say, I don't know what's happening with my case. You go to look in mass courts and there may not be anything. Not because there's not a case, not because there isn't going to be a case, but simply because you're looking within that window between when they were served and when the case is required to be filed. So if it's a summons that they've gotten very recently within the last couple of days, it's likely, more likely than not, that if you look in mass courts, you're not going to find a case for them. The other thing that I would caution is that, the information in mass courts is inputted by people typing into computers. They're very good, but how many of us make typos on a routine basis? So it is not uncommon for there to be a typo, or, the other thing to keep in mind, they're frequently reading handwritten summonses. So even though it may say Mary Smith, it actually looks like, Mary Safe, whatever. And so they've inputted it as they read it. So if you search for a tenant's name and you don't find anything, that it also is not determinative. There is no case. It's possible that there is a case, but it's listed under a different name because of the way that it was inputted into the system. So, a good practice, if you are using this system more than, just in a cursory way, is to try searching both the landlord's name and the tenant's name and see if you can find it that way. Just because I don't want to give the impression that if somebody's name isn't there, it absolutely means there's not a case. Unfortunately, it's possible that there may still be a case and you just can't find it. So it's a helpful system, but it isn't a perfect system. So those are
before we move on from mass courts, I want to highlight something that is really, really helpful in this new virtual world. Once tenants get their tier 1 notice, which will say that when the answer is due, right, 3 days before that tier 1 notice, and how to log in to the court's virtual room to have their mediation or their meeting with a housing specialist, the login information is included in mass courts. I have a case here pulled up to show you. So if you get a tenant that is calling you that has been in court or has a court date scheduled and doesn't know how to get there, doesn't know how to access it, this is a really helpful tool to be able to, so here it is, the virtual conference information, meeting ID, password, and the telephone to join via Zoom. So that is a really helpful tool for us advocates trying to advise folks on how to get to the court. If you are somebody that is Zoom savvy, as we've all grown to be, it's helpful to have the information there.
So I'm going to turn it over to Stephanie now to address kind of 2 groups that we are particularly concerned about in this virtual world. Those clients who, and tenants and landlords, frankly, who are English as a second language individuals, as well as those individuals with disabilities. I think we all know that these groups in particular have long relied on personal relationships and personal contact to navigate the world and to navigate a court system that frankly is complicated for everyone, and particularly complicated for these groups. So while we are all remote, you know, these are the groups that we are concerned are the most isolated, the most likely to miss information, to not appear at court dates, and not be able to access court. And so Stephanie is going to speak to that.
Right, and that's exactly right, Laura. Before COVID, in the era of going physically into the court, an LEP, limited English proficient individual, would come to the courthouse, and there was a big sign in the clerk's office with many, many, many languages saying, do you speak something other than English? Point to your language. And so that was a way for litigants to assert their right to an interpreter. LEP folks, again, limited English proficient folks, under Massachusetts General Laws 221C have an affirmative right to the assistance of an interpreter throughout litigation, throughout the proceedings. And the question is, how do we assert that right when we can't physically walk into the court and the clerk's office and point to a sign? Behind the scenes, we are doing advocacy to try to get a pop-up in every single Zoom screen from the court, from the trial court, saying you have a right to an interpreter. This is how you access it in several languages. And until we get there, we really need to spread the word in our community about this right to an interpreter. If folks are filling out their answer and discovery paperwork through the MAID system that we talked about last time, the Massachusetts Eviction Against Defense Eviction. Once they plug in that they speak a language other than English, a motion for an interpreter request would be printed out as a form along with the answer and discovery. And that would, that's the ideal way to alert the court that there is a need for an interpreter in a case, filing a formal interpreter request. That might not be the case for everybody. And so we really want to encourage folks to call the court or to jump on the court's virtual counter, which is open every day in the afternoons, all day in the afternoons on Tuesdays and Thursdays is staffed by attorneys for a lawyer for the day. But we really want to encourage people to signal that to the court, to jump on the Zoom and tell the court that they need an interpreter. They can call the court, they can email the court. They can also email the court. The court has signaled to us that in the email, in the body of the email, ideally folks would be emailing with a request for an interpreter attached to the email. But even if it's just flagged in the body of the email, hi, my name is Stephanie, I have an eviction case against me, this is the number of the case, and I need an interpreter in Cape Verdean, the court will treat that as a request for an interpreter and include it in the file. Once we follow up with an email, we will include the email for the court, the phone number for the Metro South court, because that's the most relevant for us. Generally speaking, there's a court helpline, and that is 833-91-COURT. And that is also a way to signal to the court that you need an interpreter. That is especially helpful for people who speak Spanish or Portuguese, because they have readily available interpreters on the line to patch you through to Metro South or whatever housing court you're reaching to express your need for an interpreter in the proceedings. In terms of needing accommodations for your disabilities, if somebody needs further support logging into Zoom because of a disability, if somebody needs to be present at the court because of a disability, they can't use the virtual tools. It's under the Americans with Disabilities Act, they are entitled to a reasonable accommodation of the court's policies and procedures. And again, to do that, the litigant just needs to flag this for the court, whether that be calling, jumping on the virtual counters, or reaching the ADA coordinator for that specific court. Here in Metro South, the current ADA coordinator is called Carmen Figueroa, and she will be replaced with Katarina Andrade once Miss Andrade is back from maternity leave later this month. And so, like I said, I will follow up with all of this in an email so that you have the email address and the contact information. But if all else fails, the court helpline covers all of the trial court. And like I said, they have Spanish and Portuguese interpreters readily available. I got one within minutes the 3 times I've called. And that number is 833-91-COURT.
Thank you, Stephanie.
No problem.
So that really is the bulk of our presentation piece to you all, and we do have about 20 minutes left, and so we're happy to open it up to questions. If anyone has any, you can either put them in the chat or you can, simply unmute yourself and ask. And I think Stephanie is now going to stop the recording.
So no one